Good morning and welcome to episode 70 of our Case of the Week series, published in partnership with 𝐲𝐶𝐬. My name is Kelly Twigger. I am the CEO and founder of eDiscovery Assistant, as well as the principal at ESI Attorneys, and I'm thrilled to be here with you this morning. Thanks so much for joining me. As you know, on the Case of the Week series, each week we choose a recently published decision from our eDiscovery Assistant case law database that highlights key issues for you to be focused on in the discovery process. And we try to talk about the practical implications of that decision for you, your clients, as well as your practice going forward. As always, you can find the link to today's decision either in the post or in the comment section, depending on whether you're viewing us on LinkedIn, Facebook, YouTube, or Twitter. And often we'll add additional links to those cases that you'll also see in the comment section. Before I get started today, I want to do a special shout out to 𝐲𝐫 Miller, who takes care of us at 𝐲𝐶𝐬, helps us put together this streaming every week, put together the new introduction that you just saw on this video, and is in general a wonderful person to work with. So thank you to 𝐲𝐫. All right, let's jump into this week's decision. This week's case comes to us, or this week's decision, I should say, comes to us from the case titled For Life Products, LLC versus 𝐕𝐢𝐫 Technical Inc. This is a decision out of the Western District of Virginia, dated May 25th, 2022, so pretty recent. This is from the Senior United States District Judge, James Jones. Judge Jones has 10 cases in our eDiscovery Assistant database. So you can take a peek at those if you're in front of Judge Jones. As always, we tag the decisions in our database as well as all the other content with our proprietary eDiscovery issues. The issues assigned to this week's decision include photograph, dismissal, sanctions, exclusion of evidence, bad faith, cost recovery, and forensic examination. All right, let's dive into the facts of this week's case. Excuse me, seasonal allergies getting to me. The underlying case that we're dealing with here is a trademark infringement dispute. And we are before the court on a motion for sanctions brought by the defendants that is based on fabricated evidence submitted in support of an amended complaint filed by the plaintiff on September 30th, 2020. As always, we want to pay attention to that date on our timeline. That first amended complaint filed in September 2020 alleged various trademark and unfair competition claims, including the fraudulent procurement of a trademark and cancellation of a descriptive trademark against the defendants. The defendants on this motion for sanctions contend that the amended complaint contained false photoshopped exhibits of the plaintiff's earlier products, as well as other misrepresentations in an effort to show that the plaintiff had senior rights to the trademark. Both companies are competing over what we'll refer to as a rejuvenate trademark. The court really starts out the decision by giving you its answer. And the court's answer is this: because of the breathtaking nature and extent of the misrepresentations and their potential effect on the litigation and the administration of justice, I will dismiss the plaintiff's action with prejudice as a sanction and award attorney's fees and costs. So right out of the gate, we know that the court dismisses this case based on the breadth of fabrication of evidence that's at issue here. And that's what I want us to focus on for purposes of our learning for Case of the Week, and what we need to pay attention to with regard to ESI. Now, timeline-wise, we said that the amended complaint was filed September 30th of 2020. Just over a year later, on August 6th, 2021, the plaintiff's then counsel files a motion to withdraw, advising the plaintiff advising the court that the plaintiff would then be represented by the current counsel that are on this motion before the court. 6 weeks later, by email, the new counsel on October 26, 2021, advised defendants counsel that the plaintiff intended to file a second amended complaint and inquired whether it could be filed by agreement. Included in the email to defense counsel was a red line copy of the first amended complaint versus the second amended complaint. So it's really the second amended complaint that's proposed to be filed, the red line showing the differences between the second amended complaint and the first amended complaint. There's no information in the decision as to whether or not there were red lines on the exhibits or that the changes to the exhibits on the second amended complaint were in any way highlighted. And I think that's important. Defense counsel did not respond to the October 26th email asking for agreement on filing the second amended complaint, but instead, 5 days later on November 1st, 2021, filed the motion for sanctions that's currently before the court. That motion for sanctions accused the plaintiff of fabricating evidence, and in particular claimed that the plaintiff intentionally fabricated and falsely represented 5 exhibits to the first amended complaint. Those 5 exhibits included listings of the plaintiff's product catalogs for the years 2016 through 2020, as well as an image from Amazon.com, which purportedly advertised one of plaintiff's products with dated customer reviews. The defendant's motion for sanctions requested that the court impose sanctions, including a dismissal of the plaintiff's action with prejudice and cancellation of 4 of the plaintiff's federally registered trademarks. So we already know from issuing the court's decision that the dismissal comes about, as well as costs on the sanctions motion. We'll get to whether the trademarks are dealt with by the court. A week after the motion for sanctions is filed, the plaintiff moved for leave to file a second amended complaint, which, if granted, would remove the disputed exhibits from the consideration and reduce the number of trademarks that the plaintiffs claim were allegedly infringed by the defendants. The court held a hearing on January 7th, 2022, so about 2 months after the motion was filed. At the hearing, the court specifically asked the parties whether they wanted to offer testimony or do any cross-examination of witnesses for materials submitted on the motions. And the parties agreed to stand on the materials that were submitted in writing, including expert reports submitted in support of defendant's motion for sanctions. The plaintiff did not ask to cross any of the witnesses. And that's important because essentially everybody put in writing exactly what they wanted the court to hear. So that was all the court had to go on. Following the hearing, the court found the following facts. That since 1999, the plaintiff has sold nearly 70 commercial and residential products, ranging from surface cleaning and renewal products to cabinet and furniture restorers to leather and fabric cleaners to spot and stain removers. That included among those sales were 6 supposed incontestable trademarks for Rejuvenate, all in capital letters. The defendants sell all-purpose disinfectants under their Rejuvenate trademark. Theirs is capitalized, the REJUV is capitalized, but the ENATE in Rejuvenate is lowercase. That's the only difference between the trademarks. Those trademarks that defendants own are sold exclusively to wellness and beauty professionals and businesses, whereas the plaintiff sells primarily to individual consumers. The court then found that as the COVID-19 cases spiked in 2020, the demand for surface cleaners and disinfectants skyrocketed. Empty store shelves quickly became a defining image of early pandemic days, and it was and continued to be a lucrative time to sell surface cleaners and disinfectants. The rights to market Rejuvenate branded antibacterial cleaner and disinfectants is thus the ultimate issue in this case. After the plaintiff filed its original complaint, one of the defendants responded by asserting 4 counterclaims against the plaintiff, alleging that the plaintiff's sale of disinfectant and hand sanitizer products infringed on their federal trademark for Rejuvenate, all-purpose disinfectants for infection control and prevention and biosecurity, which they have apparently owned since 2018. So you've got competing trademark infringement claims. In response, the plaintiff moved to amend the complaint, and attached to the first amended complaint, this is the one filed on September 30th, that the defendants claim there were fabricated exhibits, were copies of the plaintiff's product catalogs from 2016, 2017, 2018, 2019, and 2020, which purportedly contained all of the products available for sale and distribution in a given year. And we're going to find out why that particular fact was important on the amended complaint. In that amended complaint, the plaintiff specifically alleged that it had continuously sold 𝐕𝐢𝐫 antibacterial floor cleaner as early as 2016. So we're talking specifically about floor cleaner now. The product was listed in every catalog that's attached to the amended complaint, including in a 5-gallon bucket quantity. The plaintiff also attached an Amazon.com image to the complaint, which claimed that it showed consumer reviews for that antibacterial floor cleaner from March 2017 to January 2019. The plaintiff also emphasized in the amended complaint that its sales of 𝐕𝐢𝐫 branded cleaning products included, quote, antibacterial cleaners that disinfect surfaces, close quote, specifically antibacterial floor cleaner. So we've got the plaintiff filing an amended complaint in response to the defendant's claim of an alleged infringement of trademark for the floor cleaner, and they're filing images associated with that amended complaint that show that floor cleaner being listed in those product catalogs, together with an Amazon.com page with reviews of the product from clients that supposedly bought the product, filed again with that amended complaint. The defendants then, on their motion for sanctions, assert that each of the exhibits that are filed on the amended complaint were fabricated and that the plaintiff relied on those falsified documents to misrepresent its prior years of sales of disinfectant products and to bolster its claim of infringement. Now, after the plaintiffs filed its first amended complaint, the defendants became suspicious about what they perceived as a lack of support for the plaintiff's disinfectant sales claims. They then hired 2 experts. One was a forensic photographic expert to analyze the First Amendment complaint's product catalogs as well as the Amazon.com image. That expert specialized in digitally enhanced photography and was often hired as an expert to analyze the authenticity and reliability of images. You may have seen in the Johnny Depp trial recently the questions of fabrication of images that were raised there. And this is a similar kind of situation, albeit different kinds of fabrication. So point is, be aware when you're looking at images that there's a potential that there have been changes to those images that you want to be thinking about when it comes to ESI. The defendants also hired an expert in regulatory matters involving the U.S. EPA to analyze the antibacterial floor cleaners label from the product catalogs that were attached to the amended complaint. Now, keep in mind that those product catalogs that were attached to the amended complaint were never produced in discovery, and we get to that in the court's ruling in a little bit. Now, the photographic expert analyzed the product catalogs filed with the first amended complaint and compared them to those that were produced in discovery. And then he issued a written report. In his written report, the expert concluded that there were numerous alterations throughout the exhibit catalogs, including differences in type, style, font, and color, thicknesses of photo borders, label designs, and the sharpness and quality of the images. He also found several discrepancies between product bottles and their reflections, and he determined that these errors were evidence that the catalogs had been doctored. In total, the photographic expert found that nearly 30 images had been altered in some fashion, all relating to one product, the antibacterial floor cleaner, which again is the subject of the cross motions for trademark infringement. Based on his experience, the expert concluded that such changes could not have occurred through mere carelessness. Additional record evidence from the regulatory expert also showed that the exhibit catalogs were fabricated based on evidence of the labels that they could not have existed before 2021, but are included as exhibits to the amended complaint as products for sale from 2016 through 2019. So that's with regard to the catalogs. You've got both experts saying there's evidence here that says that these images were completely fabricated. Now, with regard to the Amazon.com page, the photographic expert found that the exhibit was not a screenshot of an Amazon.com webpage, as the plaintiffs represented, but was instead a PDF from Amazon.in in India. The expert found that the Indian flag had been erased from the search bar and that the domain suffix was altered from .in to .com to show that it was from the United States. In his opinion, the expert concluded that it was, quote, a mistake which he cannot conceive of having happened accidentally, close quote. Now, the plaintiffs really offered no explanation at all for the altered images in their response to the motion for sanctions. What they did offer was a declaration from the plaintiff's CEO in which he explained that the plaintiff had historically only generated, or that he explained only. So the only thing that he really said to respond to these allegations was that the plaintiff had historically generated multiple, what he called pitch catalogs, and catalogs designed for specific trade shows, and that prior counsel had inadvertently used the wrong catalogs in the first amended complaint. That explanation, according to the court, contradicted plaintiff's earlier representations to the defendant and to the court that the product catalogs contained all of plaintiff's products made available in a given year. More importantly, according to the court, the plaintiff had not provided any independent supporting evidence that would corroborate this pitch catalog theory that the CEO included in his declaration. The court found that there were no pitch catalogs produced in discovery, that invoices provided regarding sales of the floor cleaner product did not support sales of the product, and that there was a reasonable inference that the plaintiffs doctored the catalogs to make it appear as though they were selling a product that it was not selling. And because the plaintiffs did not take any testimony or cross-examine any witnesses at the hearing, there was absolutely no effort to explain or dispute this fact. The court also found that there was absolutely no legitimate explanation put forward as to the doctored images, and that the CEO ignored the evidence of the doctored images in his declaration. He basically didn't respond to it at all. The court went on to identify multiple pieces of additional behavior by the plaintiff, that were fraudulent and misleading to the court with regarding invoicing of sales for hand sanitizer and the lack of sales for 4 different trademarks that were registered to the plaintiffs. So in essence, the court found that the plaintiff was putting forth all kinds of fraudulent information to try and bolster its support for its trademarks, when in reality, it had no sales for products under those trademarks. The court really boiled it down factually to this, that the plaintiff, in order to bolster its argument that its products were sufficiently similar to the defendant's products, relied heavily on antibacterial floor cleaner sales. And the time frame of those sales is critical not only to prevail on its own claims, but also to defeat the defendant's counterclaims. Because unlike the defendants, the plaintiff does not own a federal registration in disinfectants, which would cover the floor cleaner. So it must show pre-2018 sales of a sufficiently similar antibacterial product. In essence, the fabrications of the images and the invoices and the sales information really helped the plaintiffs to meet the elements of their trademark infringement claims and to try and defeat the counterclaims brought by one of the defendants. So in terms of the court's analysis, I think one of the things that's interesting here is the court never really looks at what we would normally look at here on Case of the Week, which is Rule 37, because we're not talking about the spoliation of ESI in a context that we normally are discussing on the Case of the Week. Instead, we're talking about the fabrication of evidence and the deliberate misrepresentation of facts to the court. And the court starts with saying that it has the ability to impose the most severe sanction, which is dismissal with prejudice, where a party, quote, deceives a court or abuses the process at a level that is utterly inconsistent with the orderly administration of justice or undermines the integrity of the process, close quote. Now, The court does note that before exercising its inherent power to dismiss a case, a court has to consider 6 factors. First, the degree of the wrongdoer's culpability. Second, the extent of the client's blameworthiness if the wrongful conduct is committed by its attorney, recognizing that we seldom dismiss claims against blameless clients. Third, the prejudice to the judicial process and the administration of justice. Fourth, the prejudice to the victim. Fifth, the availability of other sanctions to rectify the wrong by punishing culpable persons. And sixth, the public interest. So, court then goes through an analysis of each of those 6 factors, some of which are combined. On culpability, the court finds, as is pretty clear from the facts we talked about, that the plaintiff clearly acted in bad faith, never owned up to their bad conduct, even when caught red-handed. And although the plaintiff argues that it should have been lauded for bringing the issues to the defendant's attention, in reality, all that happened was that the plaintiff sent a red line version of the proposed second amended complaint to opposing counsel without any explanation of why an amendment was necessary. Meaning, counsel didn't say, hey, we found out that the images included in the first amended complaint were not correct. We're giving you a second amended complaint with the correct images. We've also amended the allegations in that second amended complaint to that are properly supported by the new images. The court found, based on that failure to do that by the plaintiff, that that factor was met. Second, the court looked at blameworthiness. And the blameworthiness is really the degree to which the client was at fault or whether the litigation or misconduct was perpetrated by its attorneys. Here, there was absolutely no evidence that the attorneys did the fabricating of the evidence. From my perspective, looking at the evidence, we see that the first attorney resigned, possibly, and I say possibly because there's nothing in the decision to support this, possibly because he or she learned that the evidence in the first amended complaint that it filed had been fabricated, and the client did not want to own up to that. The second, upon being hired, within 6 weeks, immediately provided a redlined copy of a second amended complaint that corrected the wrongdoings of the first complaint. And so it makes it look like both attorneys really knew what the client's behavior was, and they had to put it before the court to be able to decide the client's fate. There are obviously things that could have happened behind the scenes as to whether or not attorneys tried to get the plaintiffs to dismiss their claims. But remember here, because there are counterclaims asserted against the plaintiffs, a dismissal won't cure the misrepresented evidence put before the court. So dismissal by the plaintiffs is not the only option here. It's not an option that will solve the problem. Okay, so on blameworthiness, the court really found that that had been met, that it was in fact the client who was responsible for the fabrication of the evidence. The third and fourth factors really look to prejudice to the defendants, and the court says that it would be hard to imagine more prejudice to a party than fabrication of evidence that is created with the intent of painting a better picture for one party over the other. The court noted that the plaintiff relied on those fabrications of evidence to increase settlement pressure on the defendant by misleading the defendants about its prior hand sanitizer sales. And the court notes that while those negotiations were ultimately unsuccessful, they certainly detracted from other litigation issues and overestimated the defendant's liability in the case. And as we know from litigating, whenever someone presents something to you, you have a need to take it to your client, but you also have a need to investigate it thoroughly. And here, taking the time to investigate those allegations thoroughly really detracted from the defendant's ability to move their counterclaims forward. So that factor, prejudice to the defendant, on the third and fourth factors here really does weigh in favor of the defendant, according to the court. Fifth and sixth factors are really the availability of lesser sanctions and the benefit to the public. And the court says here that whether a lesser sanction would be sufficient to deter future conduct, really, it wasn't going to happen. The court finds that the level of misconduct here was so severe that it is in the public interest of requiring the defrauding party to forfeit its claims. So essentially, you've misled the public so greatly here, and you've used up court resources that a lesser sanction isn't gonna cure those problems. So the court also looked at whether the plaintiff offered any alternative sanction, but the plaintiff did not. And the plaintiff also claimed that it cured the existing problems by filing the second amended complaint with new exhibits, and that it also had meritorious claims that should be permitted to go forward. The court disagreed, said that the plaintiff's subsequent attempts to remove the fabrication were really irrelevant, and that its past conduct is sanctionable, and entered the dismissal with prejudice. The court had one last quote that I think is important, in which it stated, "Our adversary system for the resolution of disputes rests on the unshakable foundation that truth is the object of the system's process, and even the slightest accommodation of deceit or lack of candor in any material respect quickly erodes the validity of the process." Close quote. So the court then grants the dismissal with prejudice, also assesses attorneys' fees and costs as within its inherent authority, particularly where the party has litigated in bad faith. So we've got a dismissal here, and fees that are awarded to the defendant and the plaintiff's claims are dismissed. Of course, there's no particular statement here, but that still means that the defendant's counterclaims are going to go forward. So not only do plaintiffs not have any claims, they still have to defend against the counterclaims brought by the defendants here. All right, what are our takeaways from this case? Well, from an ESI perspective, it's pretty important. It is that it is incumbent upon you to analyze and question the evidence that's given to you by your clients and ensure that what you are presenting to the court is legitimate evidence. It is incredibly easy to doctor electronic information. We've seen it in other cases where I'm not recalling the immediate name of the case, but where emojis were added to electronic evidence that weren't available at the time of that version of iOS that was used on the mobile device. We've seen other instances on our case of the week where information is being doctored. It's really important that you be aware that that's a potential issue and that you pay attention to that. It is so easy to alter ESI, and it's your job as counsel to make sure what you put before the court is legitimate. It does seem clear here in this case that at some point, both of the counsel for plaintiff, the one who withdrew as well as the more recent counsel, learned of the fabrication and sought to put it before the court and let the client take the lumps. And that's really the proper way to proceed when you become aware that information has been presented to the court that is incorrect. You cannot ethically hide those misrepresentations from the court, and it is in your best interest as counsel to protect you and your reputation by ensuring that if it's the client's behavior that's at issue, that the client takes responsibility for that from the court. In essence, in order to deal with these potential issues with ESI, you need to question what you are told and make sure that you're putting the puzzle pieces together before bringing a complaint, and that you're questioning any behavior from your client that, causes bells to go off, raises red flags, whatever euphemism you want to consider. Now, it is always true on the case of the week that our Monday morning quarterbacking leaves us unable to know all the facts here. And that's really the beauty of the attorney-client privilege. But at the end of the day, you only have your reputation as an attorney to fall back on. And once that's tarnished, it's very, very difficult to put that genie back in the bottle. So there's a great deal of incentive, whether you're at law firms or others, to have a new client, have a significant case. Just heed my advice. Make sure it's a good case with legitimate evidence before you bring it to the court. The ramifications are significant. Know and understand how ESI works and get experts to advise you on these issues. Your job is just to issue spot, to know that there's a potential issue, and then to get an expert. Here in this case, both the image expert and the regulatory expert were key to showing the level of fabrication that the plaintiffs had undertaken. And that would have been beyond what the average attorney can know, as well as what the average attorney could put in front of the court in terms of evidence. A court is always going to want expert testimony on those kinds of issues. Your job is to issue spot and then find experts to assist on those ESI issues, just as the counsel for the defendants did here. All right, that's our case of the week for this week. Thanks so much for joining me. I'll be back again next week with another decision from our eDiscovery Assistant database. If you are an ACEDS member and interested in using eDiscovery Assistant, there's a discount available to current ACEDS members, as well as a trial for those taking the ACEDS exam. Information on both of those are contained in your ACEDS portal. If you are not an ACEDS member but interested in using eDiscovery Assistant for your own needs or for those of your organization, you can drop us a line at support@eDiscoveryAssistant.com or go on to eDiscoveryAssistant.com and sign up for a free trial in the upper right-hand corner. Thanks. Stay safe and healthy out there, and I'll see you next week.